I still have to do my job.
Okay.
Because I have to know on the record if you wish to consider the offer, or if on the record you're saying I am not even accepting the offer. Because today's the last day. You will not get an opportunity later to go, hey, judge, I really want to change my mind.
I'm not accepting it.
Okay, but I still have to do my job.
Okay.
Okay, and I still have to go over it and let you know that if this matter goes to trial, okay, and it goes to trial, and if the jury finds you guilty on both of these charges, one is a felony possession of methamphetamine, the maximum possible penalty, a $10,000 fine up to 3.5 years of incarceration. So 1.5 years of initial confinement, 2 years of extended supervision. The second is a possession of drug paraphernalia. Okay, if you're found guilty of that charge, maximum penalty up to 30 days of jail and up to a $500 fine. Okay, and those can be ordered to be whatever the court determines a sentence is. They can be ordered to be concurrent, served together, or consecutive, served one and then served the other. This is a possession of methamphetamine felony case. I'm not saying this will happen, but because it is a felony, there is a potential that it could happen, that if you are found guilty at a trial for a felony count, the court at that date and time right after the trial could revoke your bond and have you go have to sit in jail until a sentencing. Okay, and so that would be an immediate, and again, I'm not saying that is going to happen. That is a possibility that it could happen. Okay, and so the offer here is a deferred judgment of conviction, which is a document that you enter with the state that says, as long as you abide by this condition, you don't commit any new crimes that or conduct that rises to probable cause of a crime. You do an AODA assessment. You do other certain things, and you get that documentation to the state that after a period of 12 months, the possession of methamphetamine felony is amended to a possession of amphetamine misdemeanor for costs only, no chance of jail time. Okay, with the recommendation to the court. Court can always decide, no, if you complete it, then the court can't do anything. It is simply just cost, because that is what the agreement is. So do you understand the offer that's been presented to you?
Yes, I understand it.
And do you wish to reject that offer?
Yes.
Okay, and so this matter will be going to trial. And so be prepared for that. The only way it will not go to trial is if you plead guilty to both of those accounts as they are charged, or if the state dismisses.
This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Now understand what just happened. The court carefully explained a deferred judgment offer that could potentially reduce a methamphetamine felony to a misdemeanor for costs only after successful compliance, and the defendant knowingly rejected it. That means the case remains headed toward trial, where the potential consequences are dramatically different. Was this confidence in the defense, or a massive legal gamble? Keep watching, because this courtroom session is only getting started.
Those okay?
Okay.
Otherwise, we are currently set to go to trial on the record in the matter 24 CF 189, State of Wisconsin versus Angel Barber. The state appears through Assistant District Attorney Jose Vila in person. Ms. Barber appears in person without counsel. We're set today in this matter for a motion hearing. The state did file a motion for entry of judgment and to revoke the deferred judgment of conviction. Ms. Barber, the state is claiming that you failed to complete all of your recommended AODA sessions and to provide them with the proof of such. Yes.
If I may, Your Honor, we did hear back from the Tribal Behavioral Health Clinic. She has reengaged in AODA assessment and follow-up programming. So we're requesting a hearing 60 days out just to make sure she follows through with it.
60 days. Hmm. Hmm. Hmm.
This,
You reviewed the date of the DJOC
the,
and
the motion to revoke was filed before the expiration.
no, it was not.
It was not?
It was filed on the 22nd of May. This expired on the 19th.
There should be a 60-day grace period in the deferred for filing of the motion.
Okay, let's see that.
It's paragraph 12.
Excuse me. So long as it occurred during this agreement. All right, so. And I understand for the deferred, for something like this though, this is something that should have actually been done in the beginning of the DJOC. And actually, I'm probably going to look at that more when we do these because AODAs and those types of things. And if you're going to stop engaging in those services, that's the necessary part of this agreement. You commit other crimes, all of those things that I can understand for paragraph 12 and deferring it. However, it is in your agreement and you are re-engaging, correct? Yes?
Yes.
And do you have an idea of when you're supposed to be done?
She told me that it was just, I should be meeting with her every week for 6 weeks. And then, because I was like the outpatient and all that. So it was just, I had to meet her consecutively for 6 weeks. And then we'll just go from there.
All right.
She should have sent you our recommendation or whatever she wanted.
That is what I'm looking at, Your Honor,
Yeah.
and it is for 6 weeks.
Okay. And are you still at PO Box 622?
Yes.
And telephone ends in 1275?
Yes.
Alrighty, okay. Okay. All right. And it's a big deal if you don't complete it this
I know.
next go around.
And this is a Mr. Schmidt case if that helps with the court scheduling.
Thank you. That will, and it's not going to be quite 60 days. I'm going to do August 25th at 2.
Okay.
Okay, so August 25th at 2. So hopefully you get it
It will-
completed before
yes.
then. And if you do, then I would go get that notice of completion or notes or
Yeah,
whatever.
I'll just have her printed off right then and there, and I'll just stop here on my way home because I live right in Siren.
That is perfect because then if they get everything, you won't need to come back to that hearing.
Okay.
Okay?
Okay.
This may sound like a routine scheduling decision, but the warning from the judge is crystal clear. Complete the required treatment and provide proof. Angel Barber has re-engaged in the AODA programming, and the court is allowing time for 6 weeks of follow-up sessions. But the judge literally says it is a big deal if she fails to complete it this time. Do you think another opportunity is justified, or should repeated compliance problems trigger immediate consequences?
So you can come get your notice and you are free to. Mr. Teskey. Down and slide back, or just slide back. We will go on the record in the matter 25 CF 160, State of Wisconsin versus Robert Teskey. The state appears through Assistant District Attorney Jose Vila in person. Mr. Teskey appears in person with counsel Joel Flisky. We're set today in this matter for the final pretrial. The court has received and reviewed the motion for admitting other evidence by the defense, which would include, I think it's all complaints as they relate to Jonathan Oyat and other individuals. As a defense in the case, the court has received and reviewed the state's response to the defendant's motion for other acts, admittance of other acts. The state did object to the filing and asked the court to summarily deny the matter. However, if the court is not inclined to do so, the state wanted additional time to be able to provide a response to the other acts motion. Am I missing anything, Mr. Flisky? Who's appearing in person with Mr. Teskey?
I believe that covers the matter as it currently stands, Your Honor.
All right, and Mr. Vila?
Two things I just want to note. So regarding the other acts issue, I state I did not write this, but I can certainly do that. I also believe the matter as itself is irrelevant. Defense's argument is that they want to do the third party. There's a third party that committed the crime. That's a third party perpetrator motion that wasn't filed. So I think the other acts motion is irrelevant as it stands. And then I just need to address one motion to eliminate that defense filed.
All right, and so I just have a question. You didn't write it? I thought that it says your name.
No, I did not write that specific argument in my response.
Oh, okay. Because I'm like, I swear it said.
I should have clarified. My apologies.
Okay. All right. And so the argument of it should be the third party.
It should have been a third party motion.
It really should have been a third party motion. I get where I understood where you were going with the other act, but it's really a third party motion that should be filed. So with that understanding, and if Mr. Flisky does understand that now and just didn't, maybe he was thinking differently, strategically different when he filed the motion. Is the state objecting to if Mr. Flisky is asking to be amended to a third party?
I would object, Your Honor, that the wrong motion was filed and therefore the wrong standard and analysis was provided to the court. And per the court scheduling order, today was the last day for all substantive motions, such as third party motions, to be filed and heard prior to today's date.
Before I get to Mr. Flisky, what is the state's issue with the motion in limine?
I want to pull up the specific bullet point. One moment, Your Honor. It's towards the end of it. I want to say it's 14.
Any recorded interviews or body camera?
Yes, that's correct. Defense is offering this motion eliminate without providing any statutory authority to support it. State's position is obviously there are no Mirandize or admissibility issues. All of it should come in.
All right. Okay, Mr. Flisky.
Thank you, Your Honor. Would the court prefer me to address the motion in limine or the other acts first?
Whatever you prefer.
In regards to the state's position regarding the motion in limine, item number 14, I'm not sure what they're referring to. I am citing authority under 906.11.1 in regards to the prohibition on that material. But I think that's a separate side issue. In regards to what I think is the larger issue at play here, Your Honor, the other acts motion, I would admit that that was a strategic decision on my part to file it as in other acts. I think my argument by and large will remain more or less the same, filed as a third-party motion as the court was referring to. In regards to the state's position that this was untimely filed, while certainly would have been advantageous to have filed this in advance, Your Honor, this was filed at least a week prior to the final pretrial conference, so it is, in my opinion, timely. Moreover, I think looking at the actual evidentiary issues that are at play here, the defense is asking for admission of evidence that I don't believe is very voluminous nor especially complex. It's essentially the admission of prior convictions for a third-party witness that was involved in this matter that wasn't even charged by the state. So I would ask if the court would allow to have me amend the motion to a third-party motion and file for rescheduling to be heard on that. Thank you.
When I read your motion, Mr. Polisky, I mean, it wasn't voluminous. I have to pull it up. I didn't bring the printed one in. There you go. My thought and what I was going to do here today, regardless, I wasn't going to bring it up and state that I believed it was a third-party motion versus an other acts. I'm not going to have you tell me strategically why you chose what you did unless you want to. But in reviewing my scheduling order, it does also state, you know, that with regards to the, like, an other acts motion, that has 2 weeks before a jury trial. So I'm guessing that's strategically why you chose to file an other acts motion instead of a third party motion. But my thought was, we are still out to trial. We have a month before trial. We do have time to allow the matter to be heard. But specifically then, as it relates to Mr. Vila's objection to your paragraph 14 in your motion in limine, I do understand that you have the Wisconsin statute there. And I'm going to guess, if I'm interpreting your motion correctly, you understand that they have the ability to play recorded interviews in body camera, but just not any admissible portions, which would include if there was no Miranda or any other violations occurred.
I see, Your Honor. No, I thank you for clarifying that.
But otherwise, you wouldn't have, you're not objecting to the interviews or body camera, just to any admissible parts, correct?
That's correct.
And so, quite honestly, unless there is anything that you both wouldn't stipulate and agree to is inadmissible, we wouldn't need a hearing on that portion of your motion. Only if there was a segment of, let's say, minute 1 through 3, where you say that there's definitely a violation there. This would prejudice my client if the jury were to hear it. That's the only way that it would necessitate a hearing, because quite honestly, I don't know if you want me to hear things that are not inadmissible.
Understood, Your Honor.
But that's, again, it's happened multiple times for trials in which the court did have to make a determination on whether or not that portion can be played. But so with regards to paragraph 14, I think I understand, I believe I understand where Mr. Polisky is coming from with understanding, or do you have the same understanding?
I have the same understanding now, but I do just want to put it on the record. I don't think there's any inadmissible issues with any of the body cams. So if he has a different understanding, we can certainly potentially reach a stipulation, but I have not been told otherwise.
And I'm gonna say, and that is on your shoulders, Mr. Polisky, to say if you do have any parts that you are objecting to, and to work with and speak with Mr. Polisky regarding that. And if we need a hearing, we'll get a hearing. But sometimes we don't even have the hearing until the morning of the trial.
Mhm.
But then the attorneys already have it stipulated and already set that, okay, it may be questionable minute 1 through 3. And so you just know, and if the court rules one way or the other, then we know if we can play it or we can't play it. But with regards to your motion and third party versus the other acts. I don't think that if the court were to allow the matter to at least be heard and responded to by the state, that wouldn't be too onerous for the state. And in fact, that would alleviate any potential arguments of prejudice against the defendant and or quite honestly, any ineffective assistant arguments that could come down the road, whether or not it is in fact a third party or it's in other acts or whatnot. And I don't like to have those open-ended potential appeals issues. So I'm okay with giving a date and time for a hearing. Again, we have a couple of weeks before the jury trial, but it's going to have to be kind of a quicker turnaround. Let me just try and find something. My availability is next Wednesday morning. I could do 10 a.m. And I know it's a Mr. Schmidt week, and I know it's kind of quick.
I unfortunately can't do next Wednesday, Your Honor. I have personal issues.
Obligations.
Yeah.
What about Tuesday at 11:15?
Tuesday, the 14th?
Yes. Is that too quick?
That is too quick, Your Honor. Does the court have any availability on the 16th? I could make that work.
No, I have a 2-day Supreme Court committee.
Understood.
Thursday and Friday, so I can't do the 16th or the 17th. And your week, oh my gosh, your week is completely booked. How long do you think we will need?
In the alternative, I'm willing to just submit a written response and let the court make its decision that way if Mr. Filiski is okay with that.
I don't object.
Would you think that you would need any further argument? We wouldn't need any witnesses, correct?
Perhaps a brief period for a rebuttal, but I think if the state is all right with just submitting a written response, I don't object to that.
I'm
That's
perfect.
great.
Yep.
All right, so when do you think, Mr. Vila, you can have your
I can get it done by next Friday, the 17th, Your Honor.
Friday the 17th? And I'm gonna tell you a brief rebuttal. I'm gonna actually say 16th.
The 16th?
Yeah. I'm not gonna be here, but Mr. Filiski will be able to read your response and then he can have a short reply. And I'm only saying that because I'm gonna need a chance to read this and to make a decision. And I may not I have a lot that I may not be around for the week of July 27th through the 31st, and then boom, the next week is our trial. So, for the 16th, and can you get yours done by the end of the day of the 20th, or is that too soon if you need a reply?
I'm looking to my calendar. No, I think that would be appropriate.
Or by noon on the 21st?
Noon on the 21st will work.
All right. Oh, darn it. Well, I'm gonna be in Polk County all day for an out of county matter, but I do have access to my things and I will get it when it's filed. I can print it there. I can review it there. I can determine, get an idea of what I'm gonna do and possibly get an order done. Work?
That works for the state, Your Honor.
Yes, Your Honor.
Okay. All right. Anything further we have to address today?
One last thing on part of the state. While I am fully confident Mr. Felisky has already relayed this information to his client, I would just request a lugwood right now so he knows what the offer is.
I was going to actually, well, I guess because we're not going to have a hearing. If we're not going to have another hearing, then yes, I do need to do that. So thank you. Mr. Felisky, I just want to make sure though also that you are, if you are intending to refile as a third party, then do it. If not, and you want to stand strong on another acts, then you can do that. And for strategic reasons, then you're going to have to talk to Mr. Teskey so he can understand that.
Of course.
But if you are going to amend and it wouldn't take much modification from what I reviewed of your brief, just a couple tweaking and add this law, that thing.
Certainly, Your Honor.
But if you're going to do that, do you think you can get it done by tomorrow?
Yes, I think by end of day tomorrow, I should be able to get that done.
Is that enough time for you then to be able to do your response if he is going to modify?
I'm sorry, just to make sure I got this clear, the deadline for Mr. Felisky, if he wants to amend and file something else, is tomorrow.
Right.
Yes, the 16th end of the day, that's, yeah, I should be able to make that work, Your Honor.
Okay, sounds good. So then we have everything covered. All right. Now I need to determine what the offer was. I don't know and I don't want to guess.
Yep, nope, fair enough. The offer is for a deferred judgment of conviction, 12 months, AOD and follow through, resulting in amphetamines for cost only.
Okay. And so, Mr. Teskey, I have to go over this with you, all right? Because on August 4th at 8:30 a.m. Any other questions or any other matters to address right now, Mr. Vila?
Not from my perspective, Your Honor.
Mr. Felisky?
I don't believe so, Your Honor. Thank you.
All right, thank you. And then, so I'm not going to have another hearing, but you'll get the court's decision as it relates to the motion filed by your attorney. But make sure that you are here promptly. I'm going to say
It will be.
probably 8 o'clock or whatever Mr. Felisky tells you, because the jury will be here, ready to go. They'll be coming in probably prior to 8 or around 8. We'll be ready to go after we hear all the motions, and we're not going to wait. Okay?
Okay.
All right. Thank you. We are adjourned. Mr. Matrius. We will go on the record in the matter 24 CT 107, State of Wisconsin versus Kurt Matrius. The state appears through Assistant District Attorney Jose Vila in person. Mr. Matrius appears in person without counsel. We're set today in this matter for a status conference. Mr. Matrius, this needs to come to an end.
I got the paperwork here.
What does that mean?
My driver's thing.
What?
The driver's, I got my from DMV to reinstate my license. I just gotta go pay $60 and do the written test.
And you're gonna do that today?
I'm gonna try to get in there.
Well, I'm gonna tell you, here's the deal. Again, I'm telling you, you're out of time with this court
I mean,
anyway.
They said I can't go to, my AODA for 4 to 6 weeks. I gotta go to AODA, and they said it's 4 to 6 weeks out if I can get in it. It's all paperwork right here.
Show it to Mr. Vila, because I'm gonna tell you, this is way too old. And I need to set it for trial if this isn't going to get resolved, because it's almost 600 days old, okay?
Yeah, he just needs to go talk to the DMV, pay $60 and do whatever assessment that's left. It should be quick.
Even with the AODA?
They don't mention an AODA requirement.
Okay, so hopefully that's all you need to do. So what I'm going to tell you is today, when we're done here, you're going to the DMV.
Yep.
Because they're right there.
Yep.
You're gonna pay the fee, you're gonna take the test.
Yep.
Okay?
Yep.
And I'm gonna have a hearing, very short turnaround, as in next Tuesday.
Okay.
Okay?
Yep.
So actually Monday, we're gonna do it Monday because you'll know if you pass or you don't.
Yep.
July 13 at 11, July 13 at 11. So that's this next Monday, 11 in the morning. So you're going to need to come back and you're going to say, see, I paid my fee and I passed my test.
Okay.
And then hopefully you'll have another paper that says you're eligible to get your license, and then we're good to go. Okay?
Yep.
So come get your notice. Why don't I have Cardone and Zuber? Well, because Zuber is not on the case yet. Down and slide. Okay, well, I don't have Pardon. So we're gonna go on the record in the matter 26 CM52, State of Wisconsin versus Jacob Pardon. The state appears through Assistant District Attorney Jose Vila in person. Mr. Pardon fails to appear. This matter was set for 9:15 today. It is now 9:35 and no appearance by Mr. Pardon. He was here on June 18th, in which the court set this date and time. He was given a written notice of hearing as well as orally told by the court his date and time. At the last hearing, he informed the court that he was looking at retaining Stephen Zuber, counsel from Superior. The court does not have any notice of retainer for Attorney Zuber. So neither Attorney Zuber, who is not required to appear, he does not appear, nor does Mr. Pardon. Great weather, great driving conditions. He is not here. He knew to be here. What is the state requesting?
I had asked for a warrant, Your Honor.
The court will issue a warrant, $2,500 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned. We will go on the record in the matter 25 CT 45, State of Wisconsin versus Vanessa Mose. The state appears through Assistant District Attorney Jose Vila in person. Ms. Mose appears in person without counsel. We're set here today in this matter for a status conference. Ms. Mose, you were so close and so very, very close to getting your license. Where are you now?
So just transportation and financial issues. I am going on the 15th. My worker is going to transport me to get the process going. So,
Okay,
yeah.
so
I just have to go to the DMV and do
okay,
the testing.
that's fine. Your case is only 164 days old, so I'm not as worried. And I want you to get your license because I know that you are not very far off
No,
at getting your license. Why did you miss court?
I just didn't have I had the dates mixed up. I called that day, the day I called for the day I missed court. And it was the day before, not that morning I called. I just had the days mixed up.
Okay, just try, I mean, I would say don't try, just don't get those days mixed up
Yeah,
next time.
no, that won't happen again.
Because I'm sure it's not pleasant to have a warrant.
No.
All right, so let's get another date and time. The 15th is when you're going to be able to have transportation
Yes,
to
yep.
go. August 5th at 9:15. August 5th at 9:15, okay?
Okay.
And then let's just hope and pray and
Yeah.
send all the sparkles out
Yeah.
that you have your license by that date and time. If you do, all you need to do is take proof to the district attorney's office
Mhm.
and you will not need to appear.
Okay.
And then, because the matter is to be dismissed, correct?
Yes, it's get her license and dismiss the case.
And so if you get your license and you bring it, the proof to the DA's office, it'll be dismissed.
Okay.
And then that bail money will be returned to either you or whoever posted it. Okay?
Okay.
All right?
Yep.
All right, so you can come, whatever, but we will go on the record in the matter 25 CF 174 and 25 CF 49, State of Wisconsin versus Dennis Young. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski appearing in person. Mr. Young fails to appear. This matter is set for status conferences. Mr. Young was here on June 4th for a waiver of preliminary hearing. He doesn't appear here today. He knew of today's date and time. It was scheduled for 9:15. However, it is now 9:45 and no appearance by Mr. Young. The court has given ample opportunity for him to make an appearance. For the record, Mr. Young, I don't want to say he has a terrible appearance rate for court, but not unknown to him to fail to appear to court for some hearings. Mr. Vila, is there anything, or what is the recommendation or request from the state?
Thank you, Your Honor. Given that he's not here and that Mr. Feliski has no updates about Mr. Young's whereabouts, I would ask for a warrant.
All right, Mr. Feliski, would you like to make any argument or stand?
Your Honor, I stand mute.
The court will issue a warrant, $500 cash. Only Judge may quash or posting of the cash. He will be provided a new date and time upon posting. The court will forfeit the cash previously posted pursuant to 969.13 of the Wisconsin statutes. If for some reason, Mr. Feliski, it was impossible or not, or it was impossible or beyond the defendant's control for his non-appearance here today, the court would consider perhaps quashing the warrant. So just let me know.
Understood, Your Honor. Thank
All
you.
right, thank you. You're adjourned. We will go on the record in the matter 24 CT 08, State of Wisconsin versus Brent Reynolds. The state appears through Assistant District Attorney Jose Vila in person. Mr. Reynolds appears in person. Ms. Philomena Quebec appears by video conferencing with approval of the court. We're set today in this matter for a status conference. Ms. Quebec, please update the court.
Hi, Your Honor. So I believe that we are interested in entering a plea. I'm not sure if we're able to do that today.
Yes, please.
Okay.
So he wants to plead to the charge of count 1, DRI the second for costs only. Is that correct?
Yes, Your Honor.
All right. Okay. And so, Mr. Reynolds, you wish to accept the offer?
Yes.
And your attorney is appearing by video conferencing? Do you understand you have the right to say, you know what, I want this to be on a day when she can be here in person?
No, it's fine.
But you are okay with her appearing by
Yes.
video?
Yes.
If you can't hear her or see her, she's over there on that big monitor.
Sure.
Let me know so we can make sure that you've heard and you've understood everything, okay?
Okay.
And if at any time you have any questions or concerns and you need to speak with your attorney, let me know. And I will briefly adjourn the hearing so you can either go out and give her a telephone call or I can put you in our Zoom room and set you up with a confidential breakout session, okay?
Okay.
All right. So how old are you, Mr. Reynolds?
I will be, I'm 42.
You can read, write, you understand the English language?
Yes.
Any drugs, alcohol, or medications in the last 24 hours?
No, Your Honor.
Any mental illnesses or disorders that you are treating?
No.
Do you understand that you would have the right to a trial You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes, I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here, the state would have to prove on or around January 9th, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges had been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such revocation period or thereafter, and the revocation was a result of an OWI or similar related offense. Do you understand that?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $2,500 or imprisonment of up to 1 year in the county jail or both?
Yes.
Do you understand that there is a recommendation by both parties for costs only, but I don't have to follow that? You understand that?
Yes, I do.
I could sentence you up to the maximum possible penalty if I thought it was warranted.
Yes.
Now, did you go over the criminal complaint with your attorney, that charging document where it basically says what happened and why you were charged with the offense?
Yes.
For the most part, are those facts accurate?
Yes.
Admitting here today, you in fact did operate a motor vehicle during a period of a revocation,
Yes.
and you knew you were revoked.
Yes.
Ms. Quebec, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Reynolds, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, I do.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes, she has.
Has she's answered all of your questions?
Yep.
She's done a good job because she had the other matter dismissed, right?
Yeah, she's done a very good job.
Yeah, and so she's talked to you about any defenses and all of those things and that you can go to trial?
Yes.
And are you satisfied with her services?
Yes, Sam.
Okay, so any questions right now for your attorney or for the court?
No, Your Honor.
As to count one, operating a motor vehicle while revoked, how do you wish to plead?
I plead guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation for costs is appropriate. Mr. Reynolds is here taking responsibility for his actions. Furthermore, it's an operating while revoked. It's not the most serious offense before the court here today. I think cost is more than enough to deter him from doing it again in the future. Thank you.
All right, thank you. Ms. Quebec?
I've gone over this with my client, and we are satisfied that this is fair and appropriate. Thank you, Your Honor.
Thank you. Mr. Reynolds, anything you want to add or you want to tell the court?
No, I just like to get this over with. It's been going on for a while, so
It has.
it has a long time.
And so I am glad you are stepping up, you're taking responsibility, you're being accountable. You are still in the process of getting your license.
Yes.
You still have to work out a few things. And so that's what has drug it on for as long as it has been going. And here we're going on 660 days almost. You're going to get your license. Otherwise, you're going to be back here again, starting all over, ticking that clock.
I know.
So hopefully that's not going to be the case. This is a low end crime. So what the court's going to do is all I'm going to do is assess the DNA surcharge of $200. All right. I'll waive the rest of the court costs and fees. I'm doing that because you have bigger fish to fry. You have child support. You have to take care of those. It looks like we still have $500 cash in this case. And so I'll use $200 of that to pay your court costs and fees. With regards to the rest, as you have stated previously with other cash that's been posted, that the remaining 300 will go to help bring down your child support.
Yep.
Still okay with that?
Yes, I am.
All right, so we'll take 200, we'll send 300 to child support. Hopefully that'll keep getting you whittled down and you can stay out of trouble, Mr. Reynolds.
Yes, I will.
I like Mr. Reynolds not in trouble versus you here for for any matters, okay?
Yeah.
You have 20 days to appeal. Should you fail to appeal, you do lose that right. I do need to order your DNA. So when you're done here, you're gonna go to the jail, see if they need it. If they do, they'll take it. If they don't, they'll send you on your way. You have the ability to request your DNA be expunged through a written letter to the Department of Justice, not to this court, to the Wisconsin Department of Justice. It's easy to do. Google it, or you can ask your attorney. She can explain it to you. It's just a simple letter.
Okay.
I think that covers everything, Mr. Vila.
I do see that he was picked up on a warrant for failure to appear back in May. I don't know if there's jail credit that's attached to that since it was also for a child support issue.
I'm just gonna let the child support, he set a hefty sanction for it, and this is.
That's fine. I just wanted to
Fine,
clarify.
it's just a fine. Anything else that I'm missing, Ms. Quebec?
No, Your Honor, thank you.
All right, thank you. We are good to go.
Thank you.
Now, don't forget to go see if they need your DNA, okay?
Oh.
Thank you. All right, we're adjourned. Now I have Sean Matthews, I guess, and a Motorola. I don't know who Sean Matthews is. I have a Motorola 5G 2024 and a Motorola 2026. Who are the telephones? Everybody's muted. I also have a Sean Matthews, who I'm not aware of who you are. Asking you each to unmute.
Oh,
Okay, 2026, just said, oh, who are you?
James?
Oh, you're Mr. Lightfeather?
Yes, ma'am.
Maybe you, did you try to call on two phones? Mr. Matthews, don't have me on speaker. Do you have the court off of speaker?
Yes, ma'am.
Okay, thank you. And who is Mr. Matthews?
Judge Mogan, Mr. Matthews is my recovery coach. This is Timothy Ainley. I tried to
Okay.
get onto Zoom with my phone. I finally got it, and he had you logged in also on his office computer. So we'll just go for
Okay,
my cell phone.
all right, that's fine. Okay, we do not have your attorney yet. And actually, you're not here until 10:30, but if you want to stay and hang around, you certainly may. I do have Mr. Lightfeather, but Mr. Lightfeather, I do not yet have your attorney. He's not scheduled, your case isn't scheduled until 10:15. So all of you can just hang around. The court's going to, are you Miss Taylor? I'm gonna call Miss Taylor's case and then we will wait for attorneys. You can come up here, please. Oh, all right. Well, first, have you paid your deposit?
Not yet. I wasn't sure where to bring it.
Right out there, and it needs to be done today.
Okay, yes.
Yep, so just go take care of that. I don't have Mr. White yet.
Oh,
anyway,
okay.
So,
I'll go do that.
okay, sounds good. Oh,
Yes, I can, Your Honor.
and Mr. White, you agreed to accept an appointment of Jacqueline Taylor's case, correct?
Yes, that's right.
Excellent. Okay, I have her here. She's ready to go.
Okay, good.
We will go on the record in the matter 26 CF 59, State of Wisconsin versus Jacqueline Taylor. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. White appearing by video conferencing. Ms. Taylor is in person. We're set today in this matter for an initial appearance. Mr. White, were you able to go over the criminal complaint with Ms. Taylor?
Yes, I was, Your Honor. There's one count in that. We reviewed the penalties. I acknowledge receipt of the complaint, and I can waive further reading on that, as well as waive the time limits on any preliminary hearing.
Thank you for waiving time limits. That makes things a little bit easier. I could do an August 3rd at 3:15.
Let me see, August 3rd.
If it's a waiver, you may appear by video conferencing, Mr. White.
Your Honor, right now I'm scheduled for some double booked trials in Barron on that day. I better avoid it for right now.
That is totally fine. August 31st at 3.
First. That'd work for myself.
All right, so August 31st at 3 o'clock, okay?
Okay.
And I believe you are closer in Grantsburg. Talk to your attorney. The next hearing is what's called a preliminary hearing, where the court determines whether or not there's probable cause. That's the burden, probable cause that a felony was probably committed by you in Burnett County. That's just to bind it over to see if it can continue to move on towards trial. Okay, and he will go over that, all the burdens, all the things, and then that's that next hearing. You can come up here and get your notice, and you're free to go.
All right. Thank
All
you,
right,
Your
thank you.
Honor. Thank you.
Okay, thank you.
Mr. Lightfeather, can you hear me? You are muted.
Can hear you.
All righty. We will go on the record in the matter 25 CT 33, 25 TR 492 and 493, State of Wisconsin versus James Lightfeather. The state appears through Assistant District Attorney Jose Vila in person. We have Nicholas White, Defense Counsel by video. We also have Mr. Lightfeather by video conferencing capability. We're set today in this matter for status conferences. Mr. White, can you please update the court?
Yes, Your Honor. I was able to talk with Ms. Lightfeather, Mr. Lightfeather, about the AODA. I'm not sure actually where he's at in that process. I know he had it scheduled to begin in Siren and was saving up money. When I talked to him the other day, he said that he had some housing issues. He's I think dealing with some family situation where he saved up the money, maybe used it for rent, something along those lines. He also lost his phone that had the information for all the IDIP and the things that I've been sharing with him at that point. So I think he's just kind of fallen behind on some of the IDIP initial stages here, but he's got all the information now.
All right, so Mr. Lightfeather, you're gonna have to make sure that you pick up the speed, okay? Because this is almost a year old, all right?
Yes, ma'am.
And I want you to do your best, and so does your attorney and the state, and we want you to complete the IDIP program for multiple reasons. So I am prepared to give you a little bit more time, but you do need to pick up the speed.
Thank you, Your Honor. I will.
Well. Well, I know that this is a quick turnaround, but then we can see if he is back on top of things. I do have you coming back in front of the court, at least I thought I did, at 3 o'clock. No, it doesn't look like it anymore. 3 o'clock on July 20. Oh, I looked at the wrong attorney. Sorry, Mr. White.
Okay.
August 5th at 2:45. I think I have you coming back.
That's right. I have a status hearing that day. I could do this on that time.
Okay, so August 5th at 2:45. August 5th at 2:45, and I'm gonna want a really good update, okay, Mr. Lightfeather?
Yes, ma'am.
All right. Anything else?
Not for me, Your Honor.
No, that was it for today. Thank you.
All right, thank you. We are adjourned. Mr. Ainley, it's gonna be just a bit until we get your attorney, but it's still not set till 10:30.
That's fine.
Okay. Mr. Fisher, can you hear me?
Yes, Your Honor.
Do you have this matter resolved?
Yes.
The Rhea Shabayish?
Yes.
And could we be in victims' rights compliance for that tomorrow or no? I mean, it's the same thing, same case, different person.
I just need to make sure that they know if that's going to be the case, that notice gets sent out.
Okay, because if we can schedule this for a plea and sentencing tomorrow, I just set up Ms. Roseland's for 9. I could do 9:15 for Ms. Shabayish if we can make sure we're in victims' rights compliance for her as well.
If we're in victim rights compliance, that works for me. It's very possible I would need to appear by Zoom, but I think I should be able to be there in person.
I'm fine that if you're by Zoom, as long as Ms. Shabayish is. And she is nodding her head yes.
Okay,
So,
that would work for me then.
do we want to check right now to see if we can be in victims' right? Can you send a message or something? Or
Yes, Your Honor, one moment.
I mean, we can always reschedule it tomorrow, but I think if we're having the girls come from the same general place.
No, I understand. It's just the one we knew that was trying to get pushed today was the prior case. So I will send a message back and
So if you want to hang out and just see if we can confirm, then we can. Otherwise, you can just come, I guess. Hopefully we can be in victims' rights compliance because again, same case, just different defendants. Same case, same victims, just different defendants. So what I'm gonna do is I'm just going to just have a seat in the back. We don't need to go on the record, I don't believe, just reset it to tomorrow and we'll figure it out, hopefully before tomorrow. What is the agreement that's been reached though, Mr. Fisher?
Your Honor, the agreement is that Ms. Shabayish will plead to the battery for 1 year, for a probation for 1 year withheld sentence. The state will stay silent on expungement. They're not going to argue for it, but I am allowed to argue and they're not going to object.
Okay, all right. And I'm gonna guess that that's the same or similar to the other one?
yes, Your Honor.
Excellent, okay.
Minus the expungement.
Okay, right, okay. So if you just want to have a seat back there, hopefully we can get confirmation from the DA's office. I do have other cases with Mr. Fisher. We will go on the record in the matter 25 CF 89, 26 CF 09, State of Wisconsin versus Timothy Ainley. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Zachary Fisher, Defense Counsel by video. We have Timothy Ainley by video conference capability. We're set for a status conference. Mr. Fisher, please update the court.
Thanks, Your Honor. I believe we are still waiting on results from the lab for the firearm. I don't believe that DNA results have come back yet.
All right, then I'm setting the 25 CF 89 for a trial. That needs to get going. It's almost a year old.
Yes, Your Honor.
How many? We just 1 day?
That's a 1-day trial, Your Honor.
And we don't need any lab. September 29th.
Is that for the final pretrial?
No, for the trial.
For the trial, okay.
That works for me.
All right, September 29th is the trial date. Final pretrial. I can do 1 o'clock. On August 31st.
That works for me.
Okay, August 31st, 1 o'clock. Final pre-trial. Mr. Ainley, that's the court's drop dead date. That means the court will not accept an agreement after that date, nor will the court accept a global resolution. The matter will proceed to trial on that September 29th date if an agreement is not reached by the final pretrial, okay?
Yes, ma'am.
All right, anything further with Mr. Ainley?
No, Your Honor, thank you.
Thank you. The other matter will be set for a status to track along. All right, then we are adjourned.
Thank you,
Ms.
Judge.
Berg? Ms. Berg, are you by telephone?
Yes.
Okay. You're gonna have to get out of the wind though, because it sounds like it's windy.
Is that better?
Yes.
Okay.
We will go on the record in the matter 26 CF 23, 26 TR 138, and 26 TR 139, State of Wisconsin versus Jamie Berg. The state appears through Assistant District Attorney Jose Vila in person. Ms. Berg appears by telephone conferencing. Zachary Fisher, Defense Counsel, appears by video. We're set today in these matters for status conferences. Mr. Fisher, please update the court.
Thank you, Your Honor. I did receive the inventory list that I was looking for from Siren PD. I do believe that we are very close to resolution. I would ask if we could set this for a plea date in August. Ms. Berg just needs to get verification of another one of her prescriptions that she has. And when she does that, I believe the offer would be to plead to possession of paraphernalia for costs only.
And that's correct?
That is correct, Your Honor. We're just also waiting on that one other prescription to be verified.
I could do 1 o'clock on August 3rd.
That works for me.
All right, 1 o'clock on August 3rd. At this time, both of you can continue to appear remotely. I am going to say that, well, let me look. It looks like she does have money posted.
I believe
so we are good. We're all good to go. So telephone, video, whatever is approved.
Thank you, Your Honor.
Thank you.
Thank you.
Did we get any update on victims' rights compliance?
I'm gonna head back there right now.
Oh, Vicky's right there.
Right here. I did send you an email. Today and
Yes.
tomorrow would not work, however, anytime Wednesday would work.
Your Honor, am I good to hang up?
Oh, yep, you are good. You're good to go.
Okay.
So,
Thank you.
so that's just, so it would work, tomorrow works for Roseland, but not for Shabayish.
The victim can't make court tomorrow because she needs more notice. But she can make, she wants to come and make an impact statement.
Well, we already have Roseland set for tomorrow. We got the go ahead.
That was like a day's notice. And she
2 days notice, but we just got he just literally went back to your office.
I know.
Yeah.
So
So if she wants to appear virtually, she can do that.
she can be virtually
Okay.
and make all of the impact that she wants. She can have all the time she wants. If she wants an hour, hopefully not, but she can. So, because Harrington's not here anymore.
Okay.
He left after we said it. So hopefully that can work and video will work. So we'll just schedule it for tomorrow at 9 and 9:15. And I guess we'll just see tomorrow. Did you hear that, Mr. Fisher?
Is that set for both?
Yeah.
Sorry, what was that, Your Honor?
What, Mr. Fisher?
Oh, I thought you said something to me. Sorry, Your Honor.
I said, did you hear that and does it work?
I did not hear that I had another hearing I had to step into for a second.
Oh no, that's okay. Yeah, it would Roseland has already been set and Harrington's gone. We were going to then set Shabayish right after. Quite honestly, it's for ease of victim then doesn't have to give 2 impact statements, 2 different days and 2 different things, and doesn't have to be subjected to it twice. So I was thinking then for ease of everybody, we would just do them together. Well, not together, but we could do them together, victim impact statement. You would be able to do it? We could do them together. So the victim, but do sentencing separately, because then victim only has to give 1 impact statement.
Okay.
And if
That
it
works for me.
doesn't work, then we'll deal with it tomorrow, I guess. Mr. Fisher, that
That
works?
works for me.
Okay.